Welcome, Kent County Board of Adjustment meeting, public meeting, January 16th, 2025. Could you please roll call, please?
Yes, sir. Mr. Gallo?
Here.
Mr. Carter?
Here.
Mr. Jones?
Here.
Mr. Jenkins?
Here.
Miss Denny?
Here.
Miss Hudson?
Here.
Thank you. Mr. Cusick?
Here.
That's 7 present.
Thank you. Can we do introduction of staff?
Yes, sir. Good evening, everyone. My name is Jamie Fensky. I'm the planner for this evening. To my left, we have Mark Kennedy, our IT staff. And to the far right, we had Fred Townsend, our legal counsel.
Thank you. At this time, everyone please stand for the Pledge of Allegiance. Any additions or alterations to tonight's agenda?
No, sir.
Thank you. Public hearing introduction, please.
Yes, sir. So good evening, ladies and gentlemen. My name is Jamie Fensky, and I'll preside as the hearing officer for tonight's public hearing. The hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony on this application before the Kent County Board of Adjustment. Everyone will have an opportunity to speak. This will provide those who wish an opportunity to give their testimony. If there is a group of interested citizens in favor or opposed to any of the applications, they may wish to elect one spokesperson among them to present testimony to the board. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there should be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. As a courtesy to other participants in this hearing, a maximum of 5 minutes will be allotted to any person who wishes to provide testimony. The chairperson of the board has the discretion to allow additional time if deemed to be necessary. To make statements when your application is called, and for the record, please give your name, address, and allow our attorney to swear you in prior to providing testimony. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. The procedure on each application will be as follows. The legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation of the application by the staff. The board will then receive testimony from all of those in favor, followed by all of those opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on that application will be declared closed. Decisions on the application heard this evening will be made by the board during the business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you can contact Kent County Planning tomorrow between 8 a.m. and 5 p.m. at 744-2471. All applicants will receive a written notification of the board's decision. This notice may not be mailed until after the next scheduled meeting, but if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and all future property owners. The public notice of this evening's hearing was published on December 29th, 2024 in the Delaware State News. In addition, the subject property was posted with a sign prior to the hearing and to further notify the public of the nature of the application. Thank you.
Thank you, Jamie. This time we'll have statement by counsel. Mr. Townsend.
Thank you, Mr. Cusick. The test for the granting of area variances is set forth by the Delaware Supreme Court in the case known as Board of Adjustment versus Quick Check Realty. The legal standard for area variances considers whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership. And to determine whether the exceptional practical difficulty test is met, the board must consider the following 4 factors. First, the nature of the zone where the property lies. Second, the character and uses of the immediate vicinity. Third, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And fourth, whether failure to remove the restrictions would create exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is met only when the difficulties alleged are practical rather than theoretical and exceptional rather than routine. The inability to improve one's business may qualify as an exceptional practical difficulty. And also, this consideration is where the board determines if the applicant is seeking more relief than is minimally necessary to relieve the asserted difficulty. In general, the board is not permitted to consider factors other than the four listed. Therefore, those speaking both in support of and in opposition to applications are urged to present only information bearing directly on the nature of the zoning district, the characteristics of the area, whether the requested variances would seriously affect neighboring properties, and lastly, whether applicants are confronted with challenges rising to the level of exceptional practical difficulties. In particular, presenters are instructed to exclude from the presentations any discussion of personal disputes or acrimony between the applicant and neighboring property owners, as the board is not authorized to resolve those disputes. Mr. Cusick, that's my statement.
Thank you, Mr. Townsend. At this time, we'll begin the public hearing.
Okay, so first up, we have application A-25-02. The applicants are Kevin and Patricia Allen. The owners are Brian and Chalisa Allen Chillis. Present zoning district is AR. The proposed variance is a variance from the maximum size of an accessory dwelling unit of 50% of the floor area of the principal dwelling unit to submit an accessory dwelling unit application. Present use is residential with one home out there. The proposed use is same within an accessory dwelling unit. It's located in the 6th Levy Court District for Mr. Hertz, located on the north side of Millington Road, approximately 0.31 miles west of Long Ridge Road and Blackston Road, west of Smyrna. Here you will see the floor plan of the proposed accessory dwelling unit. The principal dwelling unit is 1,848 square feet. The proposed ADU is 1,536 square feet, and that's 83.12% of the principal dwelling. The permitted ADU is 924 square feet. This is looking at the property from the front property line, or I'm sorry, from the road. Looking down the driveway, it is kind of a pipe stem property. This is looking back towards the Blackston Crossroads. And farther down, this is looking at the existing home that's there. And I believe the proposed ADU is going to the left of that. Looking back towards the main road. Again, this is kind of the area here to the left where the proposed accessory dwelling unit is going, and the existing principal home there is to your right. Looking at the property, and just around the proposed construction area, and the aerial. So if one of you folks would like to come up at a time, you can state your name and address and allow our attorney to swear you in.
Good evening, everyone. My name is Brian Chillis. My address is 3151 Millington Road, Clayton, Delaware, 19938.
Mr. Chillis, do you solemnly swear or affirm the testimony you provide in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
I would ask you to pull that microphone a little closer to
Yes,
you
sir.
as you continue with your presentation.
Yes, sir.
And you can begin now.
Yes, sir. I just wanted to start. I had a neighbor that was supposed to be here tonight, but his wife's really ill. So he wrote a letter 2 days ago. I don't know if you want me to hand that over to somebody. He wanted to come, but he couldn't make it because his wife was really ill. I apologize for that. My name's Brian Chillis, as I stated before. I've been a police officer for 11 years. Pat and Kevin Allen are my in-laws. We started this process with a general contractor 6 to 8 months ago. They gave us a bunch of false hopes about some things. They started building things that they weren't supposed to build. We've been working with the county day in and day out to try to rectify the situation that they had wronged us by. They took about $50,000 from my in-laws. Sorry, I'm a little emotional about this. They sold their house already. Sorry, Kev, 1 second. I apologize. Sorry about that. My in-laws have lived in Townsend for many, many years. I'm not sure the amount, but they built that home, I believe, in the 1980s at some point in time, 1990s. They sold that house with a realtor that was working with the general contractor that was supposed to be building the house that they were supposed to build on our property so they could be close by to us and our family. My wife is 38 weeks pregnant as I'm here tonight. They were supposed to be helping us with our child care and some other things, as well as when they grow older, we were going to provide care for them as they grow older in their life. My in-laws have since sold their house. They have to move out on February 28th. Their house was originally supposed to be done by that time for them to move into, and we're trying to figure out housing for them since this has all occurred. That's why we're here trying to propose this variance, so it's a minimal impact on our family economically and especially for my in-laws. They wanted to build their dream home next to us so they could retire and be close to our family. I'm not very close with my family. I had a lot of things going on when I was a kid. They've really taken me in since I've become part of their family. I was blessed by my grandparents to inherit this piece of property, and my whole dream was to have my family close by. And with the contractor that we had, we thought that was available, but they didn't follow any of the rules and regulations that you guys had set forth, which we had since fired them and have taken legal action for that. But we made contact with the county. They had already dug footers and things that they did not drawn permits to do that we were unaware that they didn't have yet. My in-laws actually contacted the county about the permits. We were informed that they didn't get the permits, and I had somebody come in to refill all the footers and everything that was dug incorrectly. I just would really like to thank the county for all the help that they've been in this process through making sure that we do this the right way. As I said, I would like to do this the right way because this was my dream forever, was to have family close by that my kids could grow up with their grandparents, and my wife has her parents close by. And as they've sold their house now, we're still trying to find living situations for them, as their house was supposed to be done on January 31st this year when they would have had plenty of time to move in. If anybody has any questions, I'd be happy to answer any questions. Thank you.
Thank you. Any questions?
Who was the builder?
I'm not trying to be unprofessional, but with the legal contract that we have signed with them, I'm not really allowed to, at this moment, until the contract, they don't meet their requirements of their contract by the 31st of January. I can't really speak on that. I apologize.
I have one question. Is there, or can you explain the reason why the ADU needs to be 1536?
Sir, the only reason we were applying for the ADU to be 1,536 square feet is as I said, my in-laws had lived at this piece of property where they live now for many, many years, and over the years they've accumulated quite a bit of things, furniture, comforts, and they have dogs, and they're going to be watching watching their grandchildren, my son now and my soon-to-be daughter when she's born. So to have room for them to run about and do things and just comfort room for them.
So a dwelling of 924 square feet, which is what would fit the code, would be inadequate in your opinion?
Sir, if you don't mind, I would like my mother-in-law to speak on that because it's going to be their house. I know the reasons that we had discussed was because that it's comfortable living as far as I understand.
Thank you.
Yes, sir.
What's the total acreage of the parcel? Is it, did I see 23?
23.8 or 23.9 acres, I believe, sir.
Okay.
So the construction that started and then you had filled in, that was on your property, this very property we're speaking about?
Correct, sir. We had hired my in-laws had hired a general contractor that had told them that they had applied for the proper permits and had the proper permits. My in-laws asked for those permits multiple times. and they were never provided with them. So my in-laws reached out to the county themselves to ask if the permits had been obtained, and we found out that they had not been obtained. And the contractor was then fired, and we then rectified the situation as far as we did the best we could by filling in the footers and things that they had dug without properly having a permit. We wanted to make sure that we were doing everything correctly, which we thought by hiring the general contractor, they were doing that, but we had to go around and make contact directly with the county in order to make sure that it was, and they were not. So they were fired since, and we tried to, well, we did fill in all the things that they did and removed all the stuff that they had done.
Thank you.
So when I look at these produced by the county,
Yes, ma'am.
and again, they're kind of hard to really see.
Absolutely.
But how much, I mean, a lot of this seems to be woods and wetlands, and a lot of it doesn't appear to be buildable to my, I'm not an engineer, but to my eye. So can you tell me how much around you is open?
Correct. So with the property being 23.9 acres, it's roughly, there's about 11 acres that are cleared with, I mean, there's a tree here and there, but it's not completely wooded. And the rest of that property is wooded or wetlands. So it's roughly around 11-ish acres, I would say, that's open.
So roughly 11 acres would be buildable,
I do believe so.
including.
I don't do zoning, ma'am, so I'm not 100% sure. If somebody come out and could tell me exactly, but the way that I look at it, and it was explained to me, there's 11 acres that's kind of on what they were considered an island, which would be buildable, and the rest of it is lower woodlands and wetlands.
I have a question for the staff. If you could just comment on the amount, it says here in the, on the paperwork, it said, for additional storage, the applicants could include a 1,651 square foot attached garage to the ADU. Where does that number come from?
So they can have an accessory dwelling an accessory residential building. So a detached garage, if you will, that's 10% larger than their home. And that would include all of their porches and attached garages that's on the principal home. So for just a detached garage, it can be 10% larger than the home. The accessory dwelling can only be 50% of the living square footage of the home. So they could have a 924 square foot accessory dwelling unit, but the total building itself could be that 10% that's larger than the home. So they could basically have the 2,000 something square foot detached building, and of that, 924 be the accessory dwelling unit.
So the issue is not the footprint, the issue is the amount of living area.
Yes, sir.
Thank you.
You're welcome. I do just want to add one thing. So the applicants did reach out to the county and discuss doing a minor subdivision with us. Because it is a pipe stem, this front area here is only approximately 25 feet wide. So they wouldn't even be able to do a minor subdivision as the property sits now, because the right-of-way for a private road would have to be 50 feet wide. So the applicant didn't state that, but they did reach out to the county in depth to see what they would be able to do to have two homes here. It doesn't meet the qualifications of a farm, so they wouldn't be able to have two homes for that, and they wouldn't be able to subdivide due to that front piece being not 50 feet wide.
Thank you. Yeah, I mean, that was my question, just because I saw your letter here, just to not subdivide the property, but Jamie explained it.
Yes, sir.
Any other questions?
I have one more question.
Yes, sir.
To revert back at the beginning, you had stated that Your in-laws had invested about $50,000, is that what you said in this
Yes, sir.
project already?
Yes, sir.
And that's kind of, you're going through court proceedings right now, or?
They have an attorney that's contacted the builder, and the builder has until January 31st to pay them back the money, or we have to go through court proceedings in order to try to get that money back. There was a contract signed where we couldn't speak ill of the contractor, which is why I couldn't name the contractor, as long as they meet their criteria by January 31st, which is for them to pay back all the money that they had taken from my in-laws.
But currently, they are out that money, is that correct?
Currently, they have not received not even a penny from that contractor, sir. Yes, sir.
Is any of the work that was performed beneficial to your plans?
Currently, no, sir, not right now, because we had to fill in all of the footers and everything of that nature. So we wanted to fill in the footers and everything from talking to the county about the situation that we went through. We needed to start with the variance, and there was no reason for us to have footers already dug on a property when we didn't even have the permits to do so. So I wanted to make sure that we started from where we were. Luckily, I have a friend that is a heavy equipment operator that could come in and fill those footers in for me and help me in that way. But as of right now, there's no work that is left that they did.
The house plans are already drawn up, correct?
Yes, ma'am.
Okay.
Yes, ma'am. My in-laws had the house plans drawn up, which that was another issue, that they were drawn up but not actually put into a blueprint format, which is another reason why the red flags were drawn by my in-laws, that they needed to contact the county to see what permits had been taken out and what permits had not. They have had blueprints made up and things of that nature for the house plans. Yes, ma'am.
Good. Any other questions? Good, thank you.
Thank you, sir.
Yes, sir.
Ma'am, would you like to speak on the application? Thank you. If you just want to state your name and address and allow our attorney to swear you in.
Patricia Allen, and I currently reside at 5871 Summit Bridge Road in Townsend.
Ms. Allen, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. I'd just like to say thank you for letting us come to this hearing and listening to our version of it. Everything he said, I say and feel. It's an emotional thing. I'm sorry. My husband's 60 years old. I'm 60 years old. He wants to retire. He's a heavy equipment operator. I'm a hairdresser. I want to keep working 1 day a week, and I want to take care of my grandchildren, and my husband wants to take care of the property, and we just want to live right beside them and help them with whatever we can. I feel like the family unit is very important, especially in these times, and we just want to be able to be there for each other.
Thank you. Any questions?
I have a question. So in this residence that you want to build, within it, the part of the house that where you will have your bathroom, bedroom, your living, versus, and I realize then there's some storage and probably a garage or something, but within that, is that the play area for the grandchildren, or so that's?
Yes. So we currently live in a 2-story house, and we wanted to downsize. So we want like the play area, we called it like the craft room. That would be for the baby's crib if they want to, if they want privacy. Cole's play, or my 5-year-old grandson's playthings. He loves trains. Pop-Pop sets up train sets for him. And our bedroom, a bathroom, right off of our bedroom, a walk-in closet, and a kitchen and a living room. The mud room to come in with the washer and dryer and like all the utilities to make the house work. It's considerably smaller than what we have right now, but yes, that's That's why we're asking for this variance. I understand that it's more than the 50%, and unfortunately, the contractor way misled us. She thought it was 75%, but I learned that the laws were changed in 2023 to 50%, and another lie. And she signed, we called it a mutual agreement, and it was her mutual agreement that we wouldn't talk about her ill lead to anything like the Home Builders Association, Better Business Bureau, nothing on social media. And then my lawyer put a confession of judgment at the bottom of it. And it stated that she would have 45 business days to pay us back the money that we put up. That money was for upfront materials. So it was at a discount for paying upfront materials. So she signed this confession of judgment on Thanksgiving Day, and we signed it as well, and she has 45 business days. We feel as though the money that she took from us went for another build that they were currently building, because she said, we build 2 houses at one time. This permit came in before yours. And she applied for she told me she applied for the permit in July, but we have record that it wasn't even applied for until October 6th. And they started digging the footers October 16th.
And
they didn't pour the footers, they just dug the footers.
Okay.
Any other questions? Nope. Good, thank you.
Thank you for your time.
Well, that ends public hearing. We'll continue on. We'll go to business meeting. I guess we got roll call.
Yes, sir. Mr. Carter?
Here.
Mr. Gallo?
Here.
Mr. Jenkins?
Here.
Mr. Jones?
Here.
Ms. Hudson?
Here.
Ms. Denny?
Here.
Mr. Cusick?
Here.
Thank you. That's 7 still present.
All right, I guess it's beginning of the new year, so we got to do election of officers. Any motion?
So how do you want to do it? You want to do paper ballots? We all submit a paper ballot.
We can do paper ballots. We have in the past several years someone has appointed a chairman.
So it would be a motion to appoint, and then ask for a second, and then you'd ask if there were any further motions, and make a determination from that, and then vote on the motion or motions.
Could we make one motion to keep both officers the same?
I think it would be better for the minutes if we would have two motions to elect the 2 officers.
Okay, I'll start. I make a motion that Brian Cusick remains.
I second.
Thank you.
Are there any other motions to appoint? So I think we can close the appointment process and then vote on the motion.
We also have to do the vice chair.
Yeah, but we can vote on this one and then do the same process for the next.
Okay, we'll close the motion for the chairman from Mr. Cusick. All in favor?
Aye.
Aye.
Any opposed? All right, Mr. Cusick, you're stuck. Is there a motion for vice chair?
I make a motion that Morgan Hudson remain as vice chair.
I'll second that.
Okay, so we have the motion for Morgan Hudson to remain the vice chair. Is everyone in favor?
Aye.
Aye.
Any opposed? All right, and Ms. Hudson, you are stuck.
Thank you. Now we need approval of business meetings from December 19th, 2024.
I'll make a motion to approve the minutes for the December 19th, 2024 Board of Adjustment meeting.
I'll second. Oh,
Got a motion and a second.
All in favor?
All in favor?
Aye.
Aye.
Aye. Notice of decisions, approval of notices decision from the December 19th, 2024 meeting.
I'll make a motion to approve the notices of decision A24-50, 51, 53, 54, 55, and 56 for the December 19th, 2024 Board of Adjustment meeting.
I'll second.
Got a motion and a second. All in favor?
Aye.
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 No old business. We'll move on to our application.
All right,
Application
so-
A25-02.
The applicants again are Kevin and Patricia Allen. The property owners are Brian and Chalisa Chillis, Resident Zoning District AR. Again, they're seeking a variance from the maximum size of an accessory dwelling unit of 50%. They are seeking to allow a accessory dwelling unit of 83.12%. Principal dwelling is 1,848, and the proposed accessory dwelling unit is 1,536.
Just out of curiosity, was the ordinance amended recently to reduce the standard from 75 to 50%?
It was never 75. There was different percentages out there in different rules, but we have recently amended and did a new ordinance for ADUs. Yes, but it was never 75% per se.
Thank you.
Thank you. Any discussion or motion?
Well, do we have a aerial picture of this property so you can see, like, from the road? Is it primarily wooded from, if you were standing on the road looking at the parcel, would it be wooded or? Thank you.
When I look at this, I think, number one, well, for starters, just the width, the frontage, in and of itself is an exceptional practical difficulty when you've got that pipe stove, like, just going right up there. So, I mean, it's a giant lot, but ingress and egress, I mean, there's only one right away. And that, in and of itself, for me, is an exceptional practical difficulty that belongs just to this property there. It is exceptional. It's not common there. The other thing is, I do believe there's been fraud involved, and through zero fault of their own. They began this process with an attempt to follow the rules, and a fraud was committed against them, and now they're in this situation. And I think that should weigh as we're deliberating here.
But not only that, if you take into account the amount of money that's already been spent and legal actions are pending based on that, and I would certainly applaud every effort that has been made at this point to consciously make every effort to get this corrected. That's commendable.
Can I ask another question of staff? Would it be easy to recite what the limitations are for use of the ADU?
So for the accessory dwelling unit, they have to record a deed restriction stating that the owner of the property must live in one of the units. So they could have family members live with or without charge. They could have tenants live in there, but the property owners must live in one of the units. So whether it be the principal dwelling or the accessory dwelling, they have to sign a deed restriction that will follow the property. So if and when the Chillises move, whether it be in a couple years or in 100 years, that deed restriction will follow the property, and one of those units must always be owner occupied. Did that answer your question? Okay, perfect. Thank you.
Thanks.
Well, I'll make a motion for A2502. I make a motion to approve based off the public testimony that we heard tonight. I believe removing the restrictions would not seriously impact neighboring properties, and I believe the stem pipe driveway creates an exceptional practical difficulty on the homeowners.
Second.
Got a motion and a second?
Thank you. Mr. Jones?
So,
sorry.
if we could, I think the case is largely about the inadequacy of the available square footage under the ordinance, and that's what the applicant is seeking relief from. So, as we voice our support for the motion, that we should take into consideration the testimony that 900 and some square feet of living area was inadequate for the owners.
Okay. With the public testimony being that the 924 square feet is inadequate and the 1536 would be sufficient. Thank you.
Okay. Mr. Jones?
I'm going to vote in favor in support of application of the motion of in support of application A-25-02, based on the testimony that was given tonight, and also, you know, about the hardship. They're in their pockets pretty good. There's a little financial difficulty there. I'll vote in support of this application.
Thank you. Mr. Jenkins?
I vote in support of the motion for application A-25-02, based upon testimony tonight. And clearly there is a financial hardship there that's pending. And the fact of the pipe stem drive being 25 foot would not allow for a correction on a minor subdivision.
Thank you. Mr. Gallo?
I'm going to vote in favor of the motion. I think the testimony supported that due to the layout of the property, they could not subdivide. And the improvement, the actual footprint of the improvement is no larger than an accessory building that wasn't a dwelling accessory building, would have been acceptable. So due to the testimony there, I'm going to vote in favor of that motion.
Thank you. Ms. Denny?
I'm going to vote in favor of the motion. I absolutely see an exceptional practical difficulty with compliance overall because of the width of the right-of-way at the end of this tiny little lane, I'm going to call it. I think it's not uncommon and becoming more and more common now. It used to be many years ago, and now for families to try and stay together, and that grandparents, you know, do help to take care of their children's family. And I think fraud has occurred here, which is just, to me, horrible. And and frankly, I would feel this way for anybody, but we have someone here who puts his life on the line as a police officer, law enforcement, to protect us. And I think it's turn for somebody to have his back. And legally, I mean, I'm not just saying that for that reason because I'm a law enforcement family, but I'm saying it because they did what they tend to do. They followed every letter of the law, and now they're being kicked. So I definitely think overall this is necessary.
Thank you. Mr. Carter?
I'm going to vote in favor of the motion based on all the testimony tonight.
Thank you. Ms. Hudson?
I'm going to vote in favor per my motion.
Thank you. Mr. Cusick?
I vote in favor of the motion for application 825-02, just based on the testimony given tonight, that the square footage needed is suitable for this applicant. It's nothing extravagant, not overdoing it here. And the big kicker is really the location of this thing, and it's not impacting any neighboring properties. You can't see it from any road frontage. And obviously the hardship there, financial. And then also the applicant did a due diligence to try to do a minor subdivision But obviously that triggered a few other issues.
Thank you. That's 7 in favor of the motion.
Thank you. With 7 in favor, application A 25-02 is approved. Make a motion.
I'll make a motion.
This too will pass. Yep.
Sadly, we both had to sign it. She had to sign it too.
But if
All
she
four of
doesn't,
us have to
if she
sign.
doesn't pay us in full by January 30th, I think all that's thrown out the window and I can say.
And so if we know the name, we'll all be talking about it. Okay. Motion to adjourn.
I work for the Maryland Natural Resource Police as a state gate warden, yes, sir. Yep, yes, sir.
And my daughter
And
Chelsea.
my wife's a Delaware Natural Resource Police officer. Yes, sir. Yep. Thank you.
I'm sorry, can I have a second to the motion for adjournment? Ms. Denny, you made the motion.
Yep.
Second.
Thank you.
Thank you.
Thank you all again. I really appreciate it. Thank you. Well, we really appreciate it. Thank you guys a lot. It means, you don't even know how much this means to us. Thank you. You guys have a great night. Get home safe. Take care.
All in favor for the motion to adjourn, say aye.
Aye.